Ever pondered over the financial aspects of legal cases? Well, there's an entire field dedicated to it called litigation financing. Also known under various names like professional funding, settlement funding, third-party funding, and others, litigation financing plays a crucial role in the legal world. At its core, it's a practice where a third party unrelated to the lawsuit provides funds to a party involved in the litigation. Why? Simply because legal cases can be expensive and not everyone has the resources to pursue justice. This is where litigation financing steps in, enabling parties to move forward with their legal claims without the constant worry of financial constraints. It's a tool that democratizes access to the legal system, ensuring that your voice can be heard regardless of your financial standing. Now that you know what litigation financing is, let's delve deeper into how it operates. Litigation financing might seem complex, but it's easier to comprehend if you break it down. Let's start by looking at the key players involved. Third-party funding firms play an indispensable role in litigation financing. These are companies or individuals that are not directly involved in the case, but provide funds to carry it forward. They invest in the litigation in return for a share of the proceeds if the case is successful. Think of them as silent partners, providing the financial muscle to fight the legal battle. Now, you might be wondering, what exactly does litigation financing cover? It's not just about the lawyer's fee. The funds can be used to cover a range of expenses related to the case. This may include legal fees, research costs, court fees, and even living expenses for the plaintiff during the course of the litigation. It's like a comprehensive support system that takes care of all the fiscal aspects of a legal proceeding. One of the most interesting aspects of litigation financing is the concept of non-recourse funding. It's a unique feature that sets litigation financing apart from traditional loans. In non-recourse funding, the plaintiff is not required to repay the funder if the case is unsuccessful. This means that the funding firm bears the risk of the litigation. If the case is lost, the firm loses its investment. But if the case is won, the firm shares in the financial recovery. It's a high-risk, high-reward situation, which makes the field of litigation financing both thrilling and challenging. So, to recap, litigation financing involves third-party funding firms that provide financial support for various expenses related to a legal case. The unique feature of non-recourse funding ensures that the plaintiff is not burdened with repayment if the case is unsuccessful. Litigation financing is not a one-size-fits-all solution. There are different types to consider. Now that we've talked about the mechanics, let's delve into the different types of litigation financing in the next segment. Broadly speaking, litigation financing comes in two flavors. First, we have single-case financing. As the name suggests, this involves funding for individual cases. Whether you're a business or an individual, if you have a strong legal claim but lack the necessary financial resources, single-case financing can be a game changer. It covers your legal costs, allowing you to pursue your claim without any financial stress. Then we have portfolio financing. This is a bit different. Here, funding isn't for just one case, but an entire portfolio of cases. This takes the concept of risk diversification from the world of finance and applies it to legal disputes. Law firms or businesses with multiple cases can secure financing against the entire portfolio, spreading the risk for the financier and providing a cushion for the litigant. So, whether it's a single case or a portfolio, litigation financing provides the financial muscle to seek justice. Now that we've looked at the types, how does one actually obtain litigation financing? Obtaining litigation financing is a meticulous process. Let's dive into the how-to of it all. It all starts with submitting your case information to a litigation financing company. This is your first introduction, your first handshake. You present your case, highlighting its merits and strengths. It should be a compelling narrative, one that the funding company can't ignore. Now, the ball is in the funding company's court. They conduct what we call due diligence. Just like a detective, they scrutinize your case, turning it over, looking at it from all angles. This step is crucial because the funding company has to assess the risks involved and determine if your case is a potential winner. Next, we move on to the financial evaluation stage. The funding company crunches the numbers. evaluating the potential return on investment. This will determine the amount of funding they are willing to provide. Remember, litigation financing firms are not charity organizations. They're in this game to make money. So, they need to be sure that your case has a reasonably high chance of success and a substantial payout. Once the financial evaluation is complete, the funding company will offer a funding agreement. This is where you'll see the terms and conditions of the financing. It's essential to read it carefully and understand the implications. You might want to involve your lawyer at this stage to ensure everything is in order. Some of these agreements could be quite complex, and it's critical to know what you're getting into. Now, if you agree with the terms and conditions, you sign the agreement, and voila, the funding company releases the funds. These funds can then be used to cover legal fees, research costs, court fees, and other expenses associated with the case. And with that, the litigation procedures can commence. You now have the financial backing to fight your case without worrying about the costs. The litigation financing company is now a partner in your legal journey, sharing the risks and the potential rewards. With the process clear, let's take a step back in time to understand the history of litigation financing. Litigation financing is not a new concept. It has a rich history that spans across multiple continents. In the United Kingdom, the practice gained traction in the late 20th century following the abolition of laws against champerty and maintenance. Australia followed suit, adopting litigation financing in the 90s. In the United Arab Emirates, third-party funding started gaining acceptance in the early 21st century, while in Europe, countries like Germany and Switzerland have been using this mechanism for years. In Asia, Singapore and Hong Kong opened their doors to litigation financing in the late 2000s. Meanwhile, in the United States, this practice has been around for a couple of decades, growing significantly over the years. Each of these countries has adopted litigation financing to enhance access to justice, reduce the financial burden of litigants, and to ensure fair outcomes in legal disputes. Understanding the past helps us appreciate the present benefits of litigation financing. Litigation financing isn't just about the money, it's about leveling the playing field and providing access to justice for everyone. For claimants, it lifts the financial burden that often comes with legal battles. It means that a lack of funds doesn't have to stand in the way of seeking justice. In fact, it enables individuals and businesses to pursue valid claims that they might otherwise have abandoned due to financial constraints. For investors, it offers a unique, uncorrelated asset class with attractive potential returns. It's a way of diversifying their portfolios while also contributing to a cause that promotes fairness and justice. But it's not just the claimants and investors who benefit. Society as a whole does too. Litigation financing can enhance the quality of legal advice, as it allows claimants to access top-tier legal representation that they might not have been able to afford otherwise. It can also help to deter wrongful conduct and promote corporate accountability, as it empowers those who might otherwise be too financially weak to challenge large, well-funded defendants. Moreover, it can also maximize company assets. By transferring the cost and risk of litigation to a third party, businesses can free up capital for other strategic purposes. While the benefits are clear, what's the legal status of litigation financing in India? In India, the legal landscape for litigation financing is evolving. As we traverse this terrain, it's important to recognize that there are currently no specific statutes in Indian law that explicitly regulate litigation financing. This leaves us in somewhat nebulous territory. However, it's not all ambiguity. Indian courts have, over the years, been recognizing the legitimacy of litigation financing. The legality of third-party funding, for instance, has been acknowledged in certain states, with their civil procedure codes amended to allow it. This is a significant stride towards the acceptance of this practice. Yet it's not as clear-cut everywhere. In some quarters, litigation financing stirs up debates on public policy and morality. Critics argue that it might encourage frivolous lawsuits or create conflicts of interest, while proponents view it as a means to democratize access to justice, especially for those who might not be able to afford costly legal battles. In essence, the legal status of litigation financing in India is a nuanced dialogue between evolving legal norms and traditional views of justice. It's an ongoing conversation, one that is gradually reshaping the contours of the Indian legal system. As the discourse unfolds, it's evident that litigation financing, despite its gray areas, is slowly but surely gaining recognition as a legitimate and valuable part of the Indian legal ecosystem. So, there you have it, a comprehensive look at litigation financing in India.